Restitution of conjugal right and judicial separation. Section 9 and 10. The constitutional validity of which section of Hindu Marriage Act 1955 was upheld by Supreme Court in Saroj Rani versus Sudarshan, AIR 1984. Section 9. In which one of the following decision the constitutional validity of Section 9 of Hindu Marriage Act 1955 was upheld by Supreme Court? Saroj Rani versus Sudarshan Kumar. Remedy of restitution of conjugal right is aimed at preserving the marriage. The constitutional validity of Section 9 of Hindu Marriage Act was tested in Saroj Rani versus Sudarshan 1984. T. Sritha versus Venkata Subbiah is a case related to conjugal right. Restitution of conjugal right is available to wife and husband both. Which one of the following section of Hindu Marriage Act provide restitution of conjugal right? Section 9. Section 9 of Hindu Marriage Act 1955 was held to be intra vires the constitutional by the Supreme Court in the case of Saroj Rani versus Sudarshan Kumar. Restitution of conjugal right can be claimed when there was a withdrawal from the society of other without reasonable cause, where the wife, a homemaker, does not comply with the decree of restitution of conjugal right under Section 9 of Hindu Marriage Act 1955 and inserted files for divorce and maintenance, she would be entitled for claim of maintenance. Withdrawn from the society of other within the meaning of Section 9 of Hindu Marriage Act means refusal to have sexual intercourse, total repudiation of cohabitation. If there is no resumption of cohabitation between the parties within 1 year after decree of judicial separation, the restitution of conjugal right, the marriage can be dissolved by the decree of divorce on the petition presented by either party. Is one of the spouse without reasonable excuse refuses to live with the other, the latter can seek a decree of restitution of conjugal right. If there has been no restitution of conjugal right as between the parties to the marriage for a period of 1 year after the passing of decree for restitution of conjugal right, in proceeding to which they were parties, the marriage can be dissolved on the petition for divorce by either party. A petition to restitution of conjugal right may be filed by aggrieved party to the family court. Which section of Hindu Marriage Act provide for restitution of conjugal right? Section 9. Under which section of the Hindu Marriage Act 1955 judicial separation has been provided? Section 10. Hindu Marriage Act 1955 contain minimum period of desertion for filing a suit of judicial separation is 2 years. A decree of judicial separation does not dissolve the matrimonial bond but merely suspended the marital right and obligation during the substance of the decree. Mandate that the party still continue to be husband and wife but not obliged to live together. Provided that if the party have not resumed cohabitation for a period of 1 year, either party may seek divorce. Which one of the following prerequisites prerequisite is not a ground for judicial separation of a marriage? Demand for dowry. What is the effect of judicial separation on the marital relation under Hindu Marriage Act? Marital relation is suspended. A Hindu couple having a decree of judicial separation want to live together. They can live together only after the permission of the court. If during the period of judicial separation either spouse, including in adultery, does not furnish a ground for divorce. Yes. During judicial separation, the party continue to be husband and wife, but marital right is obliged to be suspended. Bipin Chandra versus Prabhavati, Supreme Court explained the concept of desertion. Lakshman Uttam Chandra Kriplani versus Meena is a leading decision of the Supreme Court on the ground of desertion. A remedy within 5 days of the passing of a decree of annulment of marriage. Hindu Marriage Act 1955 is the marriage is valid. Under Hindu law, marriage is a sacrament. A man is prohibited to marry his daughter on the ground of affinity. According to the court ruling, custody of the Hindu child up to the age of 5 years shall ordinarily be the mother. A girl Hindu, age 14 years, marry B. A Hindu boy simply be exchange of garland in the temple in Delhi. Later on, G find that B is important. G leaves the matrimonial home and marry to A, in the following situation, G cannot be punished for bigamy because her first marriage was not valid according to improper solemnization of the marriage. A born Muslim girl up in Hindu orphanage, brought up in a Hindu orphanage, married to a Hindu boy as per Shastri writs. The marriage is invalid. A born Christian girl brought up as a Hindu, brought up by a Hindu family, married to a Hindu boy as per Shastric ceremony. The marriage is invalid. In the proceeding on a petition for dissolution of marriage under the Hindu Marriage Act 1955, the court cannot pass instead a decree for judicial separation if the ground for seeking divorce is that the other party, after solemnization of marriage, has ceased to be Hindu by conversion to another religion. Section 9 of Hindu Marriage Act 1955 was upheld as not violative of Article 21 of the Constitution of India in Srimati Harvinder Kaur versus Harminder Singh, Saroj Rani versus Sudarshan Kumar. In T. Sarisita versus Venkata Subbiah, it was held that it is unconstitutional. The constitutional validity of Section 9 of Hindu Marriage Act for the first time came in the consideration in the case of T. Sritha versus T. Venkata Subbiah, in which it was held that it was unconstitutional.